Welcome back to Good Law, Bad Law. Last week, 17 former Watergate special prosecutors co-authored an op-ed in the Washington Post laying out the case for impeachment of President Trump. On today's episode, my guest is Larry Hammond, one of those 17 former Watergate special prosecutors, to explain why the parallels are unmistakable between what is happening today and what happened in 1974, the impeachment of Richard Nixon leading to his resignation in that year, the impeachment inquiry taking place right now regarding President Trump. We're going to talk about abuse of power, obstruction of justice, all of that and more with my very special guest, Larry Hammond. We're talking about impeachment with someone who knows an awful lot about it and has a fascinating perspective. You don't want to miss this. Stay tuned. Last week, 17 former Watergate special prosecutors co-authored an op-ed in the Washington Post calling for Donald Trump's impeachment. My guest today is one of those former Watergate special prosecutors, Larry Hammond. Larry, thank you so much for being on Good Law, Bad Law. I really appreciate it.
Thank you for inviting me.
Larry, let me just go briefly through your background because it's you may be too humble to say this yourself, but this is an extremely impressive set of credentials that you bring. You graduated from the University of Texas and the University of Texas Law School, where you were the editor-in-chief of the Law Review, and then to have one very significant clerkship after law school would be pretty impressive, but you had three. First for the U.S. Court of Appeals for the D.C. Circuit, often referred to as the second most important court in the country. And then you clerked for not one but two Supreme Court justices, Justice Hugo Black and Justice Lewis Powell, before being recruited to the special prosecutor force that was involved in the Watergate prosecution in the mid-'70s. I'm going to ask you about that, of course, specifically. But then you also interrupted your private practice afterwards, spending 4 years in the Department of Justice in Washington as the first Deputy Assistant Attorney General for the Office of Legal Counsel. And we're going to have some conversation about that as well. And in addition to your private practice for the last 30-some years, you're also, of note, the founder of the Arizona Justice Project and have worked on a number of capital murder cases, defending those who've been involved in those types of cases. So really quite a stellar background. And of course, it is the background and historical perspective you bring to the issue dominating our news and our country today in terms of the actions of our president, because of the work you did on the investigation and prosecution of those involved in the Watergate scandal leading to the resignation of former President Richard Nixon. So I don't know if I left anything out, and if I did, is there anything you want to add to that?
No, although I should tell you that my colleagues from back in the 1970s often pointed out that I may be the only law clerk they know to have flunked clerking and had to retake the course.
Which, of course, is not what happened.
Well, what actually happened is that while I was clerking for Justice Hugo Black, he passed away. And I was then offered up, as is the Supreme Court's tradition, to his successor, Lewis F. Powell, who very generously accepted me as the kind of an inherited law clerk, and then asked me to stay with him for a second year. I should also observe that he served for 16 years on the court, and I am the only law clerk he ever thought about having twice. I think that may say something about the experience of having a law clerk around for too long. but I certainly learned a lot in those experiences that I think have helped shape the way I approach the law as a lawyer in private practice and as an assistant special prosecutor and at OLC.
Well, before I get to the op-ed and the case for impeachment, which I know you and 16 others have signed on to, tell us the story of how you got involved in the Watergate Special Prosecution team.
Well, it was actually entirely unplanned, I must confess. My wife and I had been planning to leave Washington, and shortly before my date of departure, I received a call from Archibald Cox's office. He was, of course, at that time the recently appointed special prosecutor. He asked me to come meet with him. I do not know who gave him my name or why I was called, but certainly I went and I met with him, excuse me, in our offices, what became our offices, on the 4th of July. I knew that we had already made plans to leave and had no intention of staying, and I think I might even have promised my wife that nothing untoward was going to happen. But Archie came into the office that morning having walked from his apartment on a beautiful 4th of July with flags in both of his lapels. And he walked in and talked about what a beautiful day it was. We visited for half an hour. I have no memory, Aaron, of what was said. I was in a total state of awe. But when I walked out, when he said he had other things to do, the secretary then said, well, you need to sign these papers. And I said, I don't think he'd offered me a job. And she said, yes, he did. It's just the way he does things. So I signed the papers, and that's how I became an assistant prosecutor. And as I mentioned to you yesterday, I was one of the youngest, if not the youngest, person in that office.
And what were the particular issues that you were working on at that time?
My primary responsibility was to work on what was then called the ITT Task Force, which was an investigation into whether the Attorney General, Richard Kleindienst, had been ordered by the President, by President Nixon, to essentially fix a very large antitrust case that was then pending in the Supreme Court. So I became very quickly something of an expert in that particular order. Kleindienst had testified in Senate confirmation hearings to become Attorney General that he had never been ordered to do anything in any case in the Supreme Court during his time as deputy, and that if he had ever been ordered, he wouldn't have accepted the order, and he would certainly remember it. In fact, when the tapes were all produced, it became clear that he had in fact received what became known as the ice water telephone call from Nixon, instructing him that he must immediately resolve that case. So his false testimony and the steps he took to cover that up became the source of most of my work, but certainly not all.
Well, that's very interesting too, to relate to the present day investigations, because I'm sure most people, if they know anything about Watergate, they know about the Watergate break-in itself, and then the actions of the president in covering up his role in that. and his administration's role in that. But there were other issues, obviously, one of which you worked on. And we see today debate over how narrowly or how broadly the House of Representatives should approach its impeachment inquiry of President Trump, limited to the issues that are unfolding day by day regarding the Ukraine, the conversation with the Ukraine president, and whether other issues should be included in that inquiry. So we're going to talk about the case for impeachment, but just on that point, do you have a sense of, I mean, clearly if there was interference, and you found there was in that Supreme Court case, that sure sounds like an abuse of presidential power and would fit into the articles of impeachment the House ultimately voted on against Nixon. Do you have a view relating that experience to where we are today in terms of how broadly or narrowly the House should approach this issue?
Well, it raises a very important question. The scope of the inquiry, the impeachment inquiry in the House, is certainly an important topic. Some of this, of course, is political and really tactical. The position that we've taken, my colleagues and I, former members of the office, is, I think, a sound one, which is that there needs to be considered an obstruction of justice count, but the scope and detail of that count in the impeachment process probably does need to be narrowed down, just so that it can be understood and developed properly. One thing you certainly learn as an investigator, either for prosecution or defense, is that getting to the bottom of details can be extraordinarily time-consuming. And so there is certainly an argument to be made for the proposition that an obstruction count should be there, but that it might best focus on a couple or a few of the most significant acts.
Well, and I've been a trial lawyer for more than 20 years, and there is a parallel in that often, as I'm approaching trial, one of the things I'm thinking about is what are my strongest theories and what are my still credible theories, but perhaps weaker theories, and I have to make a strategic choice. Do I press a weaker theory at the risk of undermining one of my stronger theories? And because of the political nature of impeachment, I would imagine that becomes even more relevant, because it isn't only what the House leaders may think, or what Democrats who are in control of the House currently, what Democrats think, because ultimately what tipped the scales in Watergate and with President Nixon was a group of Republicans from the president's own party crossing over and coming around to the idea of impeachment. So how do you see that? And your op-ed, by the way, and I want to get into this, your op-ed in a number of points directly speaks to Republicans in Congress and refers back to that moment.
It does, and it has been much on my mind, and I now know from having spent last week receiving and listening to the comments of the other signatories, having a set of issues that can be accepted by not only Democrats but Republicans, and particularly some of the most senior Republicans, I think is very important, both for legal and for public policy standpoints. The investigation of Watergate really began with a Senate Judiciary Committee investigation chaired by Sam Ervin, who was often thought of as not the most conservative leader around, but led a bipartisan investigation, and I think that's important here too.
Well, and it's hard to imagine in this day and age that that we can find anything that would enjoy bipartisanship, but on the other hand, looking at the op-ed that you and 16 other former Watergate prosecutors co-authored, you make the case that even with the information we have now, even before further hearings, and as we record this episode, there's a week of testimony from varying players in the Ukraine issue already lined up. But even before we get to that additional testimony and any additional evidence, and even as the White House continues to demonstrate non-cooperation with the House investigation, your case for impeachment is based on what is known already. Do you want to summarize what you think the case for impeachment is based on what we know already?
Well, let me say this: the approach that we've suggested is that there indeed is enough evidence right now from what is already publicly known to support impeachment. And by impeachment, I think, Aaron, it may be important to pause for just a moment to make clear that the impeachment does begin in the House and would result in orders of impeachment if approved by a majority of the House. And what we were hoping to make clear was that the evidence now available, both with respect to the Ukrainian issue and with respect to Robert Mueller's investigation, would certainly constitute grounds for impeachment. When you add to that the refusal of cooperation with the House committees in their investigation, we conclude that as well would essentially constitute a third ground, that obstruction of cooperation. And that's really based, Aaron, primarily on what you can see right now publicly from both. Let's talk about the Ukraine thing for just a moment. The combination of the partially summarized transcript of the conversation with the Ukrainian president, coupled with Trump's own statements about that event, and now followed by statements supporting the whistleblower's statement of concern. I think if you look at those things on the Ukrainian issue, there is certainly enough there to warrant a conclusion that the president essentially violated his oath of office by attempting to to obtain assistance from a foreign leader for his own, for the president's own political gain.
Well, let's leave the Mueller report just to the side for a second, because I'm thrilled to have you in particular to talk about this with, because of the background you had in the Office of Legal Counsel, and that's going to bear directly on the issue of the whole second half of the Mueller report, which dealt with obstruction, and why Special Prosecutor Mueller handled that issue in the way that he did. So let me put that to the side just for a second, because you note in the op-ed that the House, through the Judiciary Committee, recommended 3 articles of impeachment against President Nixon: 1 for obstruction, 1 for abuse of power, and 1 for contempt of Congress, and go on to say that those same 3 articles of impeachment could be brought, based on what we know already, against President Trump. And, for those particularly non-lawyers trying to follow this, the Constitution speaks of high crimes and misdemeanors, a phrase that's really not defined in the Constitution, as is true of most things in the Constitution, by the way. And then this notion of abuse of power is also a concept that may be difficult to get our arms around. So can you help us understand how what we know already of what President Trump has done and what he has acknowledged about what he has done, not to mention the open invitation he issued to the Chinese government that they should get involved in investigating his political rival, former Vice President Biden. Talk about abuse of power and how that fits into the constitutional framework, and why that's something that you see already present and clearly evidenced here.
So let's begin with an agreement here that the phrase high crimes and misdemeanors is not defined in the Constitution itself, but it has been interpreted, if you will, primarily in the political context with the impeachment proceedings that are now often talked about in the press that have occurred in the past. But I think, and I believe my colleagues agree, that to significantly abuse the office of the president for personal political gain, particularly where it involves foreign governments, is such a dramatic abuse of power that it should be seen as essentially so far beyond the pale of what a president can do, consistent with his oath of office. And one can start by looking at Article 1 of the Constitution and the powers given to him by that article, to see that using your office for personal political gain is simply beyond the pale.
Well, as you say, we're defining high crimes and misdemeanors here as abuse of power, as abuse of the president's power. But there may be those. I think there are many who would say, "Well, this is just the kind of thing that happens all the time. Politicians, Democrats and Republicans alike. Isn't this just the kind of thing that happens?" We're saying it's abuse of power because it's abuse of power. How is it an abuse of power to invite or even pressure a foreign government to interfere in our electoral process?
Well, let's look a little bit at the context of this. Maybe that helps. The Congress of the United States had, in performing its functions under Article 2, had appropriated funds to be spent for particular purposes in the Ukraine.
Right. The aid.
We now know that we had about $350 million that had been approved, that Congress had every reason to believe would be expended for its intended purpose. As is, I think, well known, the Ukraine is an ally, and Congress wanted to be sure that we were doing at least some things to assist that government in its efforts to defend against further Russian incursions. For the president then to say, "I'm not going to allow the State Department to provide that money, even though it had already been ordered, because I wanted to extract instead a political favor, if you will." I think most people, I hope, would see that as clearly abusing his role under the Constitution.
And in fact, he used that exact word. I mean, he in the conversation with Zelensky, the Ukrainian president, he says, "Hey, I want you to do me a favor." I mean, it doesn't seem like there's a whole lot of room for interpretation there. So how do we put this in context, Larry? I mean, the impeachment of Bill Clinton was seen as very controversial because it was seen as very political. I mean, but necessarily impeachment is always political because it is one of the branches of Congress that must bring an impeachment, and so perhaps every impeachment can, to some extent, be understood as having some political dimension to it. But how do you place what we're seeing unfolding now in a historical context with the impeachments of Nixon and Clinton being the ones that are, the most recent historical examples that we have to compare to?
Well, Aaron, let me see if I can explain why I see this as very much like what happened with President Nixon and very unlike what happened with Bill Clinton. For many people who care about the Constitution, possibly the most important obligation imposed by Article 1 of the Constitution is the President's obligation to take care that the laws be faithfully executed. I hope it is obvious that when a president decides to ignore or undermine a law, an appropriation passed by both houses of Congress, and does so for personal political purposes, he has essentially violated that obligation. That was true, very much true, in the Nixon case. He was prepared for whatever reason to simply ignore the laws of the United States, to obstruct the criminal investigation in that case by providing payoffs and other things. The Clinton Monica Lewinsky matter has its own dimensions, but they are not in any material way ones that I think could honorably be said to obstruct the operation of the government or abuse the office itself.
Well, and I think another point of comparison between the Nixon experience and what we're seeing today is and you've talked so far about the issue of holding up these appropriated funds as a kind of extortion for the government of Ukraine doing President Trump a personal favor and a personal political favor. But the other aspect of it, it seems to me, is that it goes to the heart of something so fundamental to our democracy, which is our electoral system. I mean, the break-in at the Watergate was not a petty breaking and entering. It was an effort to spy on President Nixon's political adversaries through the DNC headquarters at the Watergate. And similarly, here we're talking about the president involving a foreign government, perhaps multiple foreign governments, in directly interfering in our domestic election. And in terms of faithfully executing the law, what could be more fundamental than that?
Right, and that really carries you to the second major issue here, which is the Mueller report of other acts of obstruction, and there, as you know, were many of them. But and maybe we should pause just long enough to say that if all that had happened in the presidency of Donald Trump had been this event with the Ukraine and the Ukrainian president, one might argue that this by itself would not be enough to warrant the ultimate sanction of impeaching and then possibly removing a president. But I think that the context becomes very important, and the context here includes the matters investigated and the results outlined by Robert Mueller in his report.
Well, right, and that's another point of distinguishing the experience with Bill Clinton, isn't it? That many have said, while not condoning what Bill Clinton did in the White House with Monica Lewinsky, and certainly not condoning his lying about it afterwards, there's a difference between that conduct, which doesn't necessarily establish a pattern of obstruction or a pattern of abuse of power in a presidential sense, the way what President Nixon engaged in and what President Trump is accused of doing here. The fact that there's a pattern of conduct seems to be important, so that this isn't just a one-off bad act. There's a pattern of conduct here. Is that right? That's something that makes this important.
You've said it better than I did. That's the point I was trying to make. It really is that the coming together of a series of troubling events that all seem to have been undertaken for the same purpose, i.e., political gain.
Now, you mentioned the Mueller investigation. And of course, that entire probe began with what the U.S. intelligence community fairly unanimously described as Russian interference in the 2016 presidential election, and questions of whether then candidate Trump and President Trump, once the investigation began, conspired with Russian operatives in that interference. The whole first part of the findings of the Mueller investigation, though coming up short in finding prosecutable evidence of conspiracy, nonetheless detailed in pretty exquisite and disturbing detail the efforts by the president to obstruct that investigation. So why is, I'm going to throw you a very large and meaty softball here, but it's important, I think, for people to understand and to hear someone with your background as the one to explain it. Why is obstruction of justice so significant, and why is it something that rightly should be considered as an impeachable offense?
Well, obstruction obviously covers multiple kinds of conduct, but in every investigation undertaken by, and in this case with Robert Mueller's investigation, there is an important need that animated that investigation to have someone who is honorable and independent conduct that investigation. If for whatever reasons that investigation is blocked, is interfered with by active conduct from any party, we then are faced with a situation in which justice, the ultimate goal of finding a just and proper answer, is frustrated. And we see this in our criminal courts all the time. Obstruction of justice under the Title 18 crimes is one of our oldest and most often relied upon categories of prosecutable offense. And you see it often. People who are under investigation, often, rather than just saying, here's what I did and it was right, instead of taking that course, they take the steps to suborn perjury or to encourage people not to cooperate. Well, you can't have an honorable system that seeks justice if you're going to turn a blind eye to that kind of conduct. So I think that allegation of obstruction of justice or abuse of power leading to obstruction of justice really needs to be highlighted, and I hope understood by people.
Well, and of course, that's what ultimately was the sword hanging over Richard Nixon's neck, because the feeling in the way that he was challenging the investigation and the activities of Congress and even the findings in court, until ultimately there was a ruling by our Supreme Court, was to create a sense that the president was above the law or immune to the law. And if we don't have faith in our criminal justice system, perhaps most especially in how it would apply to the president, then that would be so incredibly damaging to our entire democracy. So, that brings us to the Office of Legal Counsel, because ultimately Robert Mueller detailed his findings of obstruction, but did not, and as you'll help us understand, could not recommend prosecution or criminal prosecution for President Trump's obstruction. And that takes us to the OLC, the Office of Legal Counsel. So what is the OLC in the Department of Justice, and why couldn't Special Prosecutor Mueller go further than he did?
Let me, before I turn to that, if I might, Aaron, let me just underscore something you just said, which I believe is terribly important. United States v. Nixon is to me a very important touchstone here, and I would urge anybody, lawyer or non-lawyer, to read that opinion. A unanimous opinion by an otherwise very divided Supreme Court on other issues, very quickly and resolutely concluded that for a president to refuse to respond to a lawful subpoena from a grand jury was unacceptable in our form of government and could not be allowed. I think when people read that opinion in the context from which it grew, it becomes even all the more obvious that kind of obstruction of justice, refusing to cooperate with lawful investigations, simply can't be tolerated.
And the same, and I take it the same would be true of a lawful subpoena issued by Congress, because Congress does have subpoena authority as well.
Yes, and there are other cases where there have been questions about the lawfulness of a House or Senate committee subpoena. But if you conclude that the subpoena itself is in furtherance of a lawful objective of Congress, then I would hope that the result would be the same.
Okay.
And now, turning to OLC, the Office of Legal Counsel is an office within the Office of the Attorney General. It was created in order to provide independent legal advice to the President, to the Attorney General, and other cabinet officers. The office has a very long and quite glorious history, dating back to years before I was fortunate enough to become a deputy in that office. But the importance of that office, more than anything else, had been to assure that going back to that clause in the Constitution, that the President had such guidance as he requests on taking care that the laws be faithfully executed. And in those cases where we have had attorneys general or heads of OLC who have seen their office as essentially a political office, much like any other cabinet position, the office has suffered. Its independence and the role it performs is really critical to the functioning of the President's job under Article 1. That said, OLC had issued an opinion, I believe it was in 1972 maybe, that the president could not be prosecuted criminally for a federal crime or a state crime while in office. That opinion itself is controversial. One may disagree with it, and certainly many people do. But that has been the if you will, the executive branch law established for a great long time. By the time the Mueller investigation began, and Mueller and his office concluded that since they had been instructed to perform functions within the Department of Justice, they were not free to ignore that opinion.
So that opinion, in effect, was the law applicable to federal prosecutors, in effect?
Yes.
Okay. And so
yes.
To say that the president can't be prosecuted criminally because of that OLC opinion still leaves the avenue of impeachment, because impeaching the president is not indicting him criminally by a grand jury. It's impeaching him under the Constitution's provisions that invest the House of Representatives with authority to impeach. So
yes, that's precisely
right.
That's precisely right, Aaron, and that's what the opinion, the OLC opinion itself makes clear. Under our constitutional system of government, the proper place to go to investigate and make decisions about criminal wrongdoing by the president is, in fact, the impeachment process. And unless one wishes to wait until after the president is no longer in office, that really is the properly functioning role in a separation of powers system.
And what, in terms of the case that you and your former colleagues who were involved in prosecuting the Watergate case, in terms of your case for impeachment, you include the findings of the Mueller investigation in terms of President Trump's obstruction as what the House should include in what you hope its findings will be in terms of impeachment. Is that right?
That's correct, and that's absolutely correct. And I think anyone who reads the Mueller report, particularly the second half of that report, would conclude that that is precisely what Robert Mueller and his office concluded was the proper and expected way to respond to systematic obstruction of justice.
And is the reason that you include the obstruction findings by Robert Mueller along with what we've learned already about the president's involvement in this whole Ukraine scandal because of the connections to electoral interference by a foreign government? Or is it because of the importance of obstruction of justice? Is it both?
Well, let me on this particular question, I should be careful not to speak for my colleagues who are certainly capable of speaking for themselves. But for me, in my decision to participated in this letter. It was both. I think both the obstruction of Mueller's investigation and the apparently systematic abuse of Trump's efforts during the campaign and after to encourage foreign governments to interfere with our electoral process. Those factors together, I think, deserve a full trial in the Senate.
Well, I'm reluctant to ask you what do you think will happen, because I don't know that anybody, the news every day, it seems that there's some additional wrinkle that is unwrinkling as witnesses are coming forward, additional whistleblowers are coming forward, testimony is being taken in the House even today as you and I are talking. But in the op-ed, you again direct your voice very particularly to Republicans. It's not a secret that the House of Representatives changed control in the 2018 election. We can wonder what would have happened if that had not occurred, and where we would be on the whole impeachment issue if that had not occurred, but it did. And the Democrats control the House, and they will vote. I think most people believe they will vote on some number of articles of impeachment, but then it goes to a Republican-controlled Senate. And again, hearkening back to the experience in 1974, in this Washington Post op-ed, you point out that it was a group of Republican senators, as you put it, quote, who put national interest over party loyalty and informed Nixon that his conduct was indefensible and would compel conviction by the Senate and removal from office. So I take it there is a very specific reason that this is included in your case, as you laid it out in the op-ed. What is the argument that you would make to Republicans in the Senate who we hope are listening to this episode?
Well, let me say that I think for many people in the Senate, and I believe many Republicans, evidence matters. Facts matter. And I would not hope in any way to prejudge what the Senate will do after there is, or during the course of a proper senatorial process. But let me give you just one example. Senator Grassley, he is about as Republican as any Republican could be. But you may remember that as soon as President Trump said, well, you can't believe somebody who is a whistleblower because he's acting on the basis of hearsay, Grassley was the first to respond. And what he said, I think, is very important. He said what I'm saying right now. Evidence matters. And it's when you allow people to come forward and tell what they understand, it then gives those in charge of conducting the investigation the tools to move forward. I frankly, Aaron, have little doubt that there is much more that we do not know yet than we do know. And that when this trial occurs in the Senate, if it does, we will find that there will be things that will come out, as you pointed out a moment ago, every day. And some of that may not be valid. When held up to the light of day, the Senate may dismiss some of what they hear. but they're going to hear important things. And somebody who is as open-minded as Senator Grassley and being willing to consider something that might otherwise be regarded as hearsay gives me some hope. And frankly, if it turns out that the evidence is all laid out and the evidence is compelling and would support a 2/3 vote in the Senate, and if the Senate elects not to do something about it, well, that's the way our system works. I don't have any expectation about what would happen, and I would hope that the senators will approach this in as open-minded a way as you and I would want a jury to approach evidence in a civil or criminal case.
Well, and it's an interesting aspect of the whole Watergate experience, too, that probably because it was now several years ago, I'll just say that, the people may lose sight of the fact that Republicans stood with Nixon for many, many, many months as the Watergate story in the Washington Post and the New York Times unfolded, as the investigations and the hearings as part of those investigations took place. There were many that liked Nixon, and there were many who hated Nixon. That sounds familiar. Republicans stood by their Republican president really until the end, and that wasn't a quick resolution. That took some time. So, at some point, even in this day where our politics seem more divided and more divisive than they've ever felt, at some point it seems that those in Congress, and ultimately it may come down to a handful of Republican senators, will have to decide that actually this isn't about politics after all. It's about things much more important than that. And I think that's what you and your colleagues felt that you brought to this issue coming from the Watergate experience, isn't it? I mean, there has to be a point at which this isn't about Republicans and Democrats. It isn't about liberals and conservatives. It's not about politics at all. It's about the law.
Yes, I think that's an elegant summary. Let me just add one quick phrase to this. The excessive abuse of executive privilege, there is no blanket executive privilege. No president can refuse, particularly when evidence is demanded by Congress, and most particularly by the Senate in an impeachment, to simply say, I'm not going to provide any evidence, as he often did in the Mueller investigation. That abuse itself should be enough for many Republicans to conclude, I do not want to be a part of a government that would allow a president to simply put a blanket over the truth that they need in order to perform their constitutional function.
Mm. Well, Larry, we will as we often do in the description for this episode, we'll put a link to the Washington Post op-ed piece that we've been talking about. I think we should also include a link to U.S. v. Nixon on your recommendation. It is a great and important opinion for not just historical perspective, but directly because it relates to the issues we're so concerned with today. And I want to thank you so much, Larry Hammond, former Watergate Special Prosecutor, former U.S. Department of Justice official in the Office of Legal Counsel, and of course, Phoenix attorney, and a great guest on Good Law, Bad Law. Thank you so much, Larry. I really appreciate it.
And thank you as well for the opportunity.